Well, good evening, everyone. My name is Martin Phillipson, and as Dean at the College of Law, I'm delighted to welcome you to the Cronkite Memorial Lecture in Public Law as part of the McKercher LLP lecture series here at the College. As we gather here today, we acknowledge we're on Treaty 6 territory in the homeland of the Métis, and we pay respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I'd like to begin by thanking McKercher LLP for sponsoring our lecture series for the last 4 years, allowing the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school community. We're very grateful for their support. The FC Cronkite QC Memorial Lectures were inaugurated in November 1978 to honor Frederick Cronkite, Dean of the College of Law from 1929 to 1961. I'm just entering my third year as Dean. I cannot fathom how somebody could do 32 years as Dean of the Law School. So Frederick Cronkite was quite a character. In keeping with the former Dean's primary field of interest, the lectures emphasized the area of public law. The first of this biennial lecture series was delivered by the Honourable Emmett Hall, an alumnus of the College and former Supreme Court of Canada Justice. It's all been delivered by such luminaries as Barry Strayer, the Honourable Justice Walter Tarnopolsky, the Honourable Justice Rosalie Abella, and Professor Lorne Sossin, just to name a few. I would now like to welcome our President, Peter Stoichev, the President and Vice Chancellor of the University, to introduce our guest speaker for this evening.
Well, good evening, everyone. It's wonderful to see such a tremendous turnout, and particular welcome to members of the community in Saskatoon and beyond. I always wish I could say welcome to the most beautiful campus in Canada, but people have told me I can't prove that. And so I have to say it's one of the most beautiful campuses in Canada. So welcome to one of the most beautiful campuses in Canada. Our speaker tonight is one of Canada's most recognized figures in international sport. Dick Pound graduated from McGill University with degrees in commerce and in 1967 law. During his time there, he served as managing editor of the McGill Law Journal. Much later, he would become chancellor of his alma mater. He won the Canadian Freestyle Championship 4 times, 1958, 60, 61, and 62, and the Canadian Butterfly Championship in 1961. He competed for Canada at the 1959 Pan American Games in Chicago and the 1960 Summer Olympics in Rome. He won 1 gold, 2 silver, and 1 bronze medal at the 1962 British Empire and Commonwealth Games in Perth, Australia, and he set a Commonwealth record in the 110-yard freestyle. He was elected into the International Swimming and Canadian Swimming Halls of Fame. In 2002, he received the Gold Medallion Award from the International Swimming Hall of Fame. And if that wasn't enough, Mr. Pound was also once a nationally ranked squash player. After he retired from competitive swimming, Dick Pound became a member of the Canadian Olympic Committee Executive, serving as its Secretary General and then its President from 1972 to 1982. In 1978, he was elected to the International Olympic Committee and led the negotiation of television and sponsorship deals. He was on the IOC Executive Committee for 16 years, as Vice President from 1987 to 91 and again from 96 to 2000, during which time he revolutionized the Olympic movement and transformed the IOC into a multi-billion-dollar enterprise through television negotiations, marketing, and sponsorships. He also became known as an outspoken critic of corruption within the IOC, led the inquiry into corruption at the Salt Lake City Olympics, and began campaigning in a high-profile manner for stronger drug testing. These activities led him to become the founding president of the World Anti-Doping Agency, created in 1999 to coordinate the fight against doping in sport. His leadership brought an unprecedented and high-profile scrutiny of drug testing in the Olympics and in many professional sports, including the NHL and international cycling. He served in that transformative leadership capacity until 2007 and remains a member of its foundation board to this day. Although there is much else to say by way of introduction about Mr. Pound's involvement in this crucial area, I'll limit myself to calling attention to the recent significant work he conducted in chairing the commission investigating doping in Russian track and field. The commission released its report in November of 2015, accusing the Russian state of being complicit in illegal doping, declaring it was rife with corruption, and accusing Russian Sports Minister Vitaly Mutko of cover-ups. The report released by Mr. Pound's commission instigated an Interpol investigation. Along the way, Dick Pound authored 9 books on various subjects related to his Olympics experiences, to the law, and to influential Canadians, including Chief Justice Wilbur Jackett, who was Saskatchewan-born, is one of our distinguished alumni, and was the first Chief Justice of the Federal Court of Canada. He's the most famous lawyer ever to come from Kamsack, followed by, among 5 others, former Dean Brent Cotter and Mr. Justice Dan Conkin, both of whom are here today. Mr. Pound is president of the Canadian Civil Liberties Association and of the Olympic Broadcasting Services. He is a companion of the Order of Canada, the highest level of Canada's highest civilian honor, and has been named to Time magazine's 100 most influential people in the world for his relentless efforts to rid sport of performance-enhancing drugs. Please join me in welcoming Mr. Dick Pound.
Well, good evening, ladies and gentlemen, and thank you for that introduction, Peter. It reminds me, we had a basketball coach in Canada. The national coach was a fellow called Jack Donahue, a wonderful public speaker, often called to panels and so on. And one day they said to him, Jack, we're running a bit late. Would you mind introducing yourself? Well, he said, okay. He said, hello, I'm Jack Donahue. I'm Canada's national basketball coach. I'm 61 years old, and I'm married, and I have 5 kids, and I sleep in the nude, which he said is usually only a problem on long flights. So. May I first begin by thanking those responsible for my presence here tonight. It's great to be here. It's only the second time I've actually been on campus, and it's fabulous. It's a singular honor for me to have been invited to speak in a lecture series that recognizes the contributions to the law made by one of the great trailblazers in the study of law in this country, Frederick Cronkite, a teacher and leader, as we've heard, in your own College of Law at the university. I must say I'm disappointed that I never had the chance to meet him in person, but I had learned of him in the course of writing the biography that Peter has mentioned of Wilbur Roy Jackett, one of your graduates and a Rhodes Scholar. He was a former Deputy Minister of Justice. He was the last President of the Exchequer Court of Canada and the first Chief Justice of the Federal Court of Canada. Jackett studied under Cronkite, as well as Arthur Moxon, the first law professor, James Wilfred, a.k.a. Bill Esty, Alexander James Corey, and Fred Shepard. And he was profoundly influenced by their teaching and legal rigor, and became, in my view, one of the most able and prolific jurists this country has ever produced. There was little doubt that the College of Law was by far the best law school in Canada at the time, and it has, as you know, a splendid list of distinguished alumni. As to Cronkite himself, you don't have to do much of a deep dive to get the flavor of the man. How can you not like someone who, when asked to express an opinion on a 1949 amendment to the Criminal Code that made it an offense to make, print, publish, distribute, sell, or have possession for any purposes a crime comic. He stated, and I'm quoting here, "There is no philosophical justification for such a law unless the obscenity threatens the existence of the state. In the case of a rich, growing, and vital country like Canada, such a suggestion is ridiculous. It is fantastic that in a democracy there should be any limitation placed on what people read or on their tastes, unless there is a clear and present danger to the state. This law concludes that members of Parliament have a monopoly on taste, which is an opinion I do not hold." Well, that opinion, which had been commissioned by the Canadian press, generated a flood of calls and letters, including a request to the president of the university that Cronkite be dismissed. He was not. This linkage of policy and law, so succinctly identified by Cronkite, provides a segue into the subject of my remarks this evening, which is the creation of a parallel legal universe in relation to a particular set of sport policy considerations, in this case regarding the use of performance-enhancing substances and methods, known generally as doping. When I say a parallel legal universe, I mean a set of rules separate from the established legal order, consisting of its own legislation, its own implementation, and its own enforcement. Now, without going back to ancient times, the rules of organized sport generally developed from the time of the Industrial Revolution. These rules were outside the established legal order of the day, mainly because the focus of law and legislation at that time did not extend much beyond criminal, property, admiralty, facilitation of commercial transactions, and other discrete issues. Social legislation, including such matters as education, consumer protection, health considerations, and so forth, would take a century or more to develop. But with that development, the legal order has now expanded to include virtually everything that occurs in today's society. In the beginning, however, sport was essentially unregulated, or perhaps more accurately, self-regulated. It made its own rules and enforced those rules independently from the existing legal system. It was sport organizations who determined the rules of play, including eligibility of players, the conduct and duration of contests, the equipment to be used, matters such as age, gender, and weight classifications, the penalties for any breach of the rules, and so forth. As sport developed and became more popular, largely as a result of the increased ability to travel provided by the harnessing of steam, the focus changed to achieving standardized rules to eliminate the many local variations that had existed in the pre-travel days. The standardization of the rules occurred first on regional and national levels, and later spread to the creation of international rules for each sport, overseen by international federations. Now, stripped to its essentials, what is sport? It is a voluntary human activity governed by a set of rules to which the participants agree. At this stage of the analysis, how and by whom the rules are established are not that important, but the rules are the essence of sport. No one is forced to participate in sport, but if one does, one's conduct in that context must conform to the applicable rules. Participation, therefore, implies an implicit undertaking that one will comply with those rules, and that there will be consequences if sporting conduct does not conform with the rules. Minor breaches can generally be dealt with as part of the rules of play by penalties, penalty loops, loss of possession of the ball, additional distance loops, and other appropriate remedies. More serious breaches may include disqualification, loss of results, suspension, or even exclusion from any further participation. And consequences are generally proportionate to the nature and seriousness of the particular breach. So looking at the precursors to the parallel universe regarding doping, as I speak this evening, there are specific sport rules that prohibit doping. Those rules are, however, really quite a recent phenomenon. When I participated in swimming at the 1960 Olympic Games in Rome, there were no sport rules that prohibited doping. The International Olympic Committee, the famous IOC, and the International Amateur Athletics Federation had each expressed concern about some of the substances being used by athletes to enhance performance, but had taken no formal action to amend their rules to prohibit what we now call doping. So far as swimmers were concerned, we were unaware of any drug use in our sport. We all knew that weightlifters used anabolic steroids. They'd been obtained through the veterinary channels, not medical. You know, if we can bulk up cattle, we can certainly bulk up you. And that use of anabolic steroids had spread to the field events in track and field, hammer, discus, shot put, and javelin, and so forth. And we also knew that some athletes use stimulants while in competition. But it was at these same games in Rome, however, that things began to change. And it took the death of a Danish cyclist who collapsed and died during the road race, at least partly due to the use of amphetamines, to cause that change to begin. It spurred the IOC to establish a medical commission with a doping and a subcommission on doping and biochemistry. The subcommission had been given a mandate to try and discover what drugs were being used and to prepare a list of drugs and procedures that should be prohibited, principally with regard to the health risks of the athletes. That was done, and by the time of the Olympic Winter Games in 1968 in Grenoble, for you historians, the IOC began testing Olympic athletes at the Games. And they were the first specific sport rules that prohibited doping. There was, unfortunately, very little impact of such Olympic testing across the full spectrum of sport. The IOC had and still has only one event, the Olympic Games, which occur once every 4 years for summer and winter games. The IOC had no authority to test athletes except at its own event, namely the Olympic Games. So for essentially 3 years and 11 months out of every 4-year period, athletes trained and competed under the jurisdiction of their respective international federations or national Olympic committees, both of which were very jealous of their autonomy. There were additional difficulties. One was the development of scientifically reliable tests. You can't sanction an athlete for doping unless the doping could be proven. A second was that while the IOC now had rules prohibiting doping, the overwhelming majority of international federations did not. A third was that there was very little money in Olympic sport. These were the days before the huge television and sponsorship contracts. A fourth was that there was generally complete denial among sports authorities that doping existed, at least in their sports. And a final complication was that many of the prohibited substances or methods could be used during the training period, be stopped sometime prior to the competitions, with athletes still benefiting from of the use of these things. I mean, a good steroid program will last you 4 or 5 years, just as an example. But having stopped, by the time you get to the competition, even though you have the benefit of it, there's no evidence of the substances in the systems of the athletes. So there would have had to be an out-of-competition testing regime in place to detect that kind of activity. The IOC used the little influence it had at the time, before it became a significant source of funding, to try and persuade international federations to test at their world championships. And with the exception of certain race day drugs, normally stimulants, there was very little impact on the doping activities. The anti-doping system, if you could dignify these sporadic activities as a system, was eventually acknowledged to be completely inadequate. This took longer than it should have. Part of the reason was the Cold War that followed World War II, during which East and West were pitted against each other, led by the Soviet Union on the one hand and the United States on the other, in which athletes became de facto surrogate warriors, continuing that war on the playing fields. Sports victories demonstrated political dominance. Winning mattered. Losing was politically unacceptable. In the East, the doping programs were organized, implemented, and enforced by the state. The acknowledged leader in these endeavors was the German Democratic Republic, but all members of the Warsaw Pact were active. In the West, although the governments were not active in the design and implementation of doping programs, they were nevertheless in no hurry to put their athletes at a perceived disadvantage in competitions and turned a blind eye to possible infractions. US and Western sports authorities did the same. Now, on the surface, none of this was acknowledged. Not a single country was willing to state that sport was anything but a peaceful exchange between sports persons abiding fully by all of the rules, including those that prohibited doping. This posture was enabled by the fact that doping had become sufficiently developed for athletes and their entourage to ensure that by the time of a competition on a certain date, the athletes would be clean during those competitions. I remember in Montreal, there was a boat in the harbor. It was a Polish flag, had a couple of labs on board, and all of the Eastern Bloc athletes were taken down the day before their competitions and tested. And if they tested positive, suddenly they became ill or had an injury and were withdrawn from the competition. So there was never a positive case. Anyway, there was never the slightest indication given by either side that doping was condoned. On the contrary, any suggestion that it was nevertheless occurring was met with vigorous and indignant denial. From the sport perspective, this was nothing but a political hijack. Sport was relegated to the minor supporting role of providing athlete warriors to support political objectives. Its own aspirations to provide an international system of ethically based fair competitions were completely subjugated. Only results mattered, not the methods by which they were achieved. This type of attitude also leached into sport even when the Cold War considerations were not involved. Prize money and other incentives were certainly definite factors in such decisions. So let's sharpen the focus here a bit on a parallel universe. Sport needed to find a way to recapture its ethical foundation. The rules against doping have two principal components: protecting the health of athletes on the one hand, and on the other, protecting the integrity of sport itself. One of the essentials of sport is the uncertainty of the outcome of any event or game based on athletes or teams competing under a certain set of rules. That uncertainty is compromised, even destroyed, if those rules are not observed. Sport has therefore an inherent interest in preventing and eradicating doping. Where cheating is rampant and can affect the results of competition, people will stop participating in sport or watching as spectators because they're being defrauded through fixed outcomes. And as a side, from a health perspective, think of yourselves as current or future parents and consider the impact of doping on the physical and emotional health of your children. You might well decide to steer them away from sport or at least away from high-performance sport in those circumstances. From an overall perspective, if people stop watching sport, broadcasters will have no incentive to put the events on the air, and sponsors will have no interest in being associated with fixed outcomes. The money required to support organized sport will dry up. Sport and the players and the people around them will be responsible for the disappearance of the funds that they actually need to survive. And doping, I should say, is not the only form of corruption that can produce outcomes of this nature. The same can happen as a result of, say, match fixing. Well, when seeking solutions, it was immediately obvious that national laws regarding doping in sport were inconsistent and in many cases entirely lacking. The prospect of harmonizing worldwide legislative approaches to doping was all but impossible to visualize. Cultural, linguistic, and legal differences, together with legislative priorities, for example, in countries in which sport doping is insignificant in relation to the other and more pressing challenges faced by governments, precluded any realistic possibility of progress in that direction. On the other hand, sport realized that a solution had to be found that would lead to similar outcomes no matter where the particular conduct occurred. So the challenge for sport, therefore, became to develop specialized mechanisms to suit its particular needs rather than try to rely on the normal legal and social systems to back up its activities. It needed the parallel legal universe that I mentioned at the outset of these remarks. What then are the principal elements of such a parallel universe? What do you need to make this work? Well, the following checklist was easy to prepare, but I can tell you, not easy to accomplish. And there is, because of the ins and outs, there is some overlap and partial duplication. But let's begin. First and foremost was the need to create an acknowledged governing association having both a mandate and jurisdiction to adopt and enforce the applicable rules. Then to ensure participation of the necessary stakeholders, including athletes, officials, and governments. Next is the drafting of special rules dealing with the subject matter, namely doping in sport, and that doping is really quite different from the recreational use of drugs. With respect to testing, it's necessary to have an international network of accredited laboratories that can be legally presumed to have conducted reliable tests or reliable scientific analysis, rather, of samples in accordance with recognized international scientific standards. Also required in relation to its testing system are special compliance-related monitoring mechanisms dealing with matters that include test distribution plans to maximize the effectiveness of the testing, identification of those who are authorized to administer the tests and under what conditions, athlete whereabouts requirements. You've got to be able to find where the athletes are in order to test them, and finally, test results management to make sure that the proper outcomes are dealt with. Because scientific knowledge is continually expanding, regular scientific review of prohibited substances and methods is essential so that the list can be regularly updated. You also need an assured source of revenues in order to make sure that the ongoing viability of the governing organization is not compromised. Creation of disciplinary rules and procedures is required, as well as the ability to impose sanctions where breaches of the rules occur, combined with a willingness to impose such sanctions when appropriate. Fit-for-purpose dispute resolution mechanisms outside the usual state-created legal order are required. Educational and research programs need to be developed and disseminated, and regular consultations with stakeholders are essential to the workings of the organization. Now, there's yet another focus that is also required, which is that athletes who do not cheat need to be protected from those who do cheat. And at a minimum, this requires, to go back, testing and the application of scientifically reliable tests with respect to proof of doping, the use of any other form of reliable evidence as to doping, whether documentary evidence, evidence provided by whistleblowers, eyewitnesses, or even from statistical analysis, such as the athlete biological passport. A system that will provide any person accused of doping with a fair opportunity to defend him or herself, an independent arbiter who will determine whether or not a case of doping has been made out on the basis of the available evidence. And finally, a commitment on the part of everyone connected with sport to insist that the rules will be applied to everyone. You are no doubt familiar with the ongoing controversy regarding Russia's recent deliberate flouting of the rules. So, the parallel universe that results from all this, that universe is the one administered by the World Anti-Doping Agency, called WADA, which was established in 1999. WADA has a unique hybrid governance structure in which 50% of its members are governments, and the other 50% are drawn from the sports movement. And it has in the context of sport, a unique governance revenue structure as well, that the contributions come equally from governments and sport itself. The applicable anti-doping legislation in this universe is the World Anti-Doping Code, drafted by WADA, which in turn has been incorporated into the internal rules of the IOC, every Olympic International Federation, and every National Olympic Committee. WADA has also worked with governments to put in place the Unesco International Convention Against Doping in Sport, which has now been ratified by more than 180 countries, pursuant to which governments, for their part, agree, among other things, that the code will be the basis for their actions against doping in sport. The code provides that the final arbitrator, or arbiter in matters of doping, is the Court of Arbitration for Sport, sometimes referred to as CAS, and not the state courts in each country. This has a number of advantages, including that CAS arbitrators are expert as well as independent, that the process is faster and cheaper than in state courts, and that CAS awards can be applied in some 140 jurisdictions pursuant to the New York Convention, whereas judgments of state courts are enforceable only within the territory of the state in which they're issued. As lawyers and law students, you certainly know that the court system is one of the pillars of any legal order, and the Court of Arbitration for Sport is a showcase element in the parallel universe. Alternative dispute resolution, ADR, has become an increasing part of worldwide measures for the resolution of disputes. Most lawyers are aware of such processes, and there are many systems available, especially in matters of commercial law. And examples would be the American Arbitration Association, the so-called AAA, and the International Chamber of Commerce. As I say, there are a number of advantages to this process. They include speed, confidentiality, which you don't get in the ordinary court system, expertise, and the ability to have some input into the selection of the arbitrators who will decide the matter. Well, until 1984, there was no comparable ADR system in international sport. Some countries had domestic procedures that lent themselves to sport matters, but these were few and generally not sophisticated. And I should add something of a bragging footnote here for Canada, to observe that we have become a leader in respect of resolving national sports-related disputes through the Sport Dispute Resolution Centre of Canada. One of the outcomes of the 1981 Olympic Congress in Baden-Baden and the arrival of a new IOC president was the desire to have an ADR mechanism for sport. And this is what led to the creation of CAS by the IOC. Its initial purpose was to provide a service for the resolution of sports-related disputes entirely funded by the IOC. Modest offices were provided for purposes of administrating CAS, and a list of arbitrators was prepared. Now, sport, like almost any other segment of society, is generally change adverse, so it took some time for sports organizations to develop a familiarity with CAS and to have confidence in the quality of the arbitral awards. But this has grown over the years, and many of these organizations now include provisions in their rules and even in their contracts to the effect that sports-related disputes will be brought to CAS for resolution. Even the IOC, a notoriously conservative organization, now agrees that disputes involving decisions of the IOC itself can be heard before CAS. In its original iteration, the IOC did not give jurisdiction to CAS to hear appeals against the IOC, since it had the rather grand view that as the, quote, supreme authority, unquote, of the Olympic movement, its decisions should not be subject to appeal. Practical reality eventually set in, and that posture was abandoned. Now, it created a little difficulty because once the IOC agreed to allow IOC-related disputes to come before CAS, the structure of CAS had to be somewhat modified, since CAS then had to be independent from the IOC in order to be recognized as an independent arbitral body. Previously, the IOC, as I mentioned, had simply appointed the members of the governing body. So this modification in jurisdiction led to establishing something called the International Council of Arbitration for Sport, known by its initials ICAS, which consists now of 20 members, all with legal backgrounds. 4 members each are appointed by the IOC, the international federations, and the National Olympic Committees. Those 12 then select 4 additional arbitrators after looking for people who have a demonstrated understanding of the issues that would affect athletes who are typically involved in most of the doping-related disputes. And then finally, an additional 4 members selected from the larger international arbitration community to make sure that CAS is well-grounded in the best practices of arbitration. CAS has its official seat in Lausanne, Switzerland, and as such is subject to the oversight and the supervision of the Swiss Federal Tribunal. This tribunal, the highest court in Switzerland, has recognized CAS as an independent arbitral body, the decisions of which are entitled to deference on the part of state courts. It will generally only interfere when there have been errors as to the jurisdiction of CAS or where the rules of natural justice or due process have not been followed, including the full right to be heard. As a reminder, a particular advantage for an international sports system now in our context of a recognized independent arbitral body is that its decisions can be forced in countries other than Switzerland. The New York Convention applies to these decisions, and they can be enforced, as I mentioned, in some 140 countries, all of the major countries. This is quite different from decisions of state courts. For example, Jamaican courts have complete confidence to decide on any matters brought before them, but only in Jamaica. Their decisions have no effect anywhere other than in Jamaica. So if you want to enforce a judgment of a Jamaican court in Canada, you would have to convince a Canadian court to issue its own judgment to the same effect, which may basically amount to retrying the case. So the uncertainty of being able to rely on the New York Convention is considerable, and it removes a great deal of the uncertainty in international sport. I mean, imagine the case where an international athlete is declared ineligible to compete in a certain sport. The athlete may appeal, and this has happened in the past, to the courts in his or her country, and the courts may disagree with the international decision and decide that the athlete is eligible. So they say, the national courts say, well, you're eligible. Eh? We think the International Federation of whatever it was wrong. Well, that judgment only applies in that particular country. So you have the almost anomalous result of the athlete being allowed to compete in his or her country, but nowhere else in the world. As it relates to doping, and pursuant to the World Anti-Doping Code, which has been adopted by both sport and government, CAS has the exclusive jurisdiction as the final court on such matters, not the state courts. And I must say that my impression is that the state courts and their enabling governments are quite happy with this outcome. First, it relieves the pressures on already crowded court schedules. Secondly, the state courts recognize that they do not have the expertise required for such matters. Doping appeals can be highly technical, where challenges regarding the applicable scientific principles and forensic methodology are involved, where laboratory procedures that have occurred are examined, and where expert evidence evaluations are required. In addition, as many of us will know, the pace of regular court proceedings is not suited to the speed with which sport disputes need to be resolved. You may have to resolve something by tomorrow to find out whether an athlete advances from one round to the next, for example. While I'm sure this will vary according to particular locations, just in my part of the world, in the Superior Court of Quebec in Montreal, the delay to obtain a hearing on the merits of a civil case can be as long as 4 years from the time the parties are ready to proceed. And these days, these delays in civil cases may get longer in view of the recent Supreme Court of Canada decision in Jordan. One illustrative example regarding speed are the ad hoc divisions that CAS provides at the Olympic Games and some other major international competitions, where a reasoned judgment must be rendered within 24 hours of the filing of the request for arbitration. Now, state courts will always remain for their citizens, as they should, the court of last resort. But those courts will nevertheless require that the same citizens first exhaust their recourses in accordance with any applicable rules. If, as in the case of international sport and doping, those rules require that appeals be arbitrated before CAS, the state courts will insist that such process be followed. If at the end of that process there is a claim that the rules of natural justice have not been followed, for example, the courts may step in, but they will not, in the absence of such a failure, purport to substitute their opinion for that of the arbitral court. For those of you who may have followed the Lance Armstrong saga, you will recall that Armstrong tried to have the allegations regarding his doping be brought before the U.S. courts, rather than to submit to arbitration as required under the code and under the cycling union rules. The U.S. court refused, not without some concern as to whether justice would be rendered, but said, first you have to follow the sport rules, then you can come to me. Armstrong was unwilling to arbitrate, and we all know the outcome. His results were annulled, and he's been declared ineligible for life from cycling. And he later confessed in a particularly Armstrong manner that he had doped all along. CAS, as part of its activities, has taken steps to ensure that it keeps up with the technological advances so that parties can file their documents electronically from anywhere in the world, Hearings can also be held anywhere in the world at the convenience of the parties or by video conference. And we've even established a fund designated to provide some financial support for athletes who cannot afford to pay for legal assistance. So I think the verdict on CAS as this showcase element in the parallel universe is that it serves the needs of the stakeholders in international sport quite well. Not all of its judgments have been universally applauded, and there have been some anomalous outcomes, but that's a feature that's common to all courts. Let me finish by talking about one of the most recurrent public expressions of concern regarding doping, and this surrounds the so-called protection of the legal rights of athletes. Although much of this, in my view, is focused on protection of the guilty as opposed to protection of those who are being cheated. The defense bar in these actions continually attempts to portray charges of doping in sport as engaging the highest levels of criminal constitutional protection. This overlooks the fact, of course, that such charges are not criminal in nature. They're administrative sport rules and part of the parallel universe. The standards of proof are certainly less than criminal. The standard for a finding of that a doping offense has occurred is the so-called comfortable satisfaction of the hearing panel, which is lower than proof beyond a reasonable doubt. And the corresponding burden of proof on somebody accused, say an athlete, is the civil burden of the balance of probabilities. I can assure you that no one in the anti-doping field or in the parallel universe wants an innocent athlete to be sanctioned. Cases are only brought where there is a genuine belief on the basis of the available evidence that doping has occurred. So let me stop there. That is a brief description of a particular parallel universe that I think has so far operated very effectively. It's not perfect, and it can always be improved, but the principles have been established, the systemic matters have all been dealt with, and there is a way through the wilderness for almost any circumstance. What we have to do is make sure that the people in charge of sport are really willing to face the problem of doping and try and deal with it. Thank you very much.